Welcome to the latest episode of Gowling WLG's Employment Essentials podcast, where we discuss the latest developments and challenges affecting employment law in the UK.
Hello and welcome back to our TUPE Club podcast series. We're now on our third podcast in this mini series of TUPE Tuesday. Each week we're looking at a key appeal level TUPE case, and next week, which is the final podcast, we'll look forward to what TUPE developments we might see in 2023. I'm Siobhan Bishop, a Principal Associate in the Employment, Labour and Equalities team at Gowling WLG, and in this week's TUPE Tuesday podcast, we'll look at a case about whether rights to participate in a share incentive plan, which were under a separate collateral contract, transferred under TUPE. And this is the Employment Appeal Tribunal case called Ponticelli UK Limited and Gallagher. So as always, the background facts are very relevant. And here, Mr. Gallagher's employment transferred to Ponticelli under TUPE transfer, which occurred on 1st of May 2020. He had previously been employed by Total Exploration, the transferor, and Mr. Gallagher had been a member of a share incentive plan. Under that SIP, for each share Mr. Gallagher was allowed to buy, Total Exploration, his employer, contributed funds to him to buy 2 further matching shares. The SIP operated in accordance with a separate trust deed and plan rules, which stated that the SIP was not part of any employment contract. And the explanatory booklet about the SIP specifically dealt with this and said that if the relevant part of the business in which an individual was employed was sold, then their shares must be sold or transferred to the individual or into Total Exploration's vested share account within 90 days of the date of cessation of the individual's employment. Now, Mr. Gallagher's participation in the Total Exploration SIP ended when his employment was transferred to Ponticelli, which was on the 1st of May 2020, and the shares then held on his behalf were transferred to him. Ponticelli, his new employer, told Mr. Gallagher that as compensation for the fact that it was not going to provide a SIP post-transfer, Mr. Gallagher would receive a one-off payment of £1,855, which was a sum equivalent to twice his average contributions to the SIP over the preceding 2 years. Mr. Gallagher was not happy about this and applied to the tribunal for a determination under Section 12 of the Employment Rights Act 2006 that he was entitled, as a Ponticelli employee, to be a member of a SIP equivalent to the Total Exploration Plan. Mr. Gallagher argued that his right to participate in an equivalent SIP transferred to Ponticelli under Regulation 4.2a of TUPE, and that happened on the 1st of May 2020. So let's remind ourselves about the relevant background law. As we know, under TUPE, the relevant employees transfer under TUPE with their employment rights, which are essentially protected. The specific wording in the TUPE regulation is that all of the transferor's rights, powers, duties and liabilities under or in connection with the transferring employee's contract pass to the transferee. And it's this wording which I want to highlight, the wording about the rights in connection with the employment contract, and these were central to this case. And that is the specific wording which Mr. Gallagher said meant he had the right to participate in an equivalent SIP following the transfer. Now, a SIP is a type of tax-advantaged employee share scheme where shares are held in a special employee benefit trust. There are tax benefits, assuming that there's compliance with the legal requirements, where there is no income tax or national insurance contributions on those shares. Even where an individual who participates in a SIP ceases to be a group employee because his employment has transferred to a new employer under TUPE, the individual's shares won't be subject to the plan, but there is still a tax exemption, meaning there is no liability to income tax. Of course, if the individual's rights to participate in the share scheme are contractual, they would clearly transfer under TUPE to the transferee. And there may be practical difficulties in replicating a scheme provided by the old employer, but that's what the case law requires. It is for the transferee to provide an equivalent scheme in those circumstances. Although it is not always clear how to measure equivalence, but that is set out in the case from 2002 called Mighty Managed Services Limited and French. Here the issue was slightly more complicated for Mr. Gallagher because the Total Exploration SIP was entirely separate from the contract of employment. So what did the Employment Tribunal decide? Well, the Tribunal found in favour of Mr Gallagher and said that his right to participate in the SIP was part of his overall financial package and was caught by the wording under Regulation 4.2a of TUPE. Mr Gallagher was only entitled to participate in the SIP because he was an employee of the company. It was a benefit that was for employees and it was revenue approved. If the SIP wasn't regarded as part of the financial package, it would undermine the purpose of TUPE and possibly encourage attempts to try to avoid the transfer of financially significant benefits under TUPE. Essentially, the Tribunal did not accept that the terms of the SIP were capable of isolating it from the effect of TUPE in this case. So, after the transfer to Ponticelli, Mr Gallagher was entitled to participate in a SIP of substantive equivalence or comparable value to the SIP operated by Total Exploration. The Tribunal also made a declaration that Mr Gallagher's terms and conditions of employment should reflect the obligation to provide him with a SIP of substantial equivalence to the Total Exploration Plan on the same terms as set out in the Total Exploration explanatory booklet. Ponticelli appealed to the Employment Appeal Tribunal. So what do you think the EAT said about the case? Well, it's not really surprising that the EAT dismissed the appeal. The appeal centred around the key point of whether Regulation 4.2a of TUPE applied. However, the EAT said that the SIP rights and obligations clearly arose in connection with the employment contract, and that was the wording that I highlighted at the start of this podcast. Now, when Mr Gallagher originally joined the Total Exploration SIP, there was a contract with mutual rights and obligations between Mr Gallagher and Total Exploration, and these obligations included, in particular, Mr Gallagher agreeing to certain deductions from his monthly salary and Total Exploration agreeing to use that deduction to buy shares for him. Total Exploration also agreed to give Mr Gallagher additional matching shares at no further cost to him. And of course, Mr Gallagher was only eligible to join the SIP because he was employed by Total Exploration. But even if the obligations by the partnership share agreement did not arise under the employment contract, they did plainly arise in connection with that contract, and so were covered by the relevant regulation under TUPE and transferred to the transferee, Ponticelli. Total Exploration had tried to rely on the judgment in the Court of Appeal case of Chapman from 1987, which separated the share options from the claimant's employment. Now, in the Chapman case, the claimants were given options to buy shares, which were only exercisable after a fixed period of time, except in limited circumstances, which included them being made redundant. And following a transfer in that case, the transferee in Chapman refused to let the claimants exercise their options, arguing that their employment had not ceased. The Court of Appeal in that case agreed that the claimant's employment had not ceased under TUPE, but that their share option contracts were separate from their employment contracts. And it was possible in that case for the claimants to have ceased to have been employed by reason of redundancy as required by the share option agreement, and they were entitled to exercise their options. However, the Employment Appeal Tribunal said that the decision of Chapman only considered if it was under the contract and not whether it was in connection with the contract. And the Chapman case had been subject to much academic criticism and doubt as to whether it would be followed today. In any case, the Chapman case was distinguishable, as the share option scheme was different to the SIP being offered in this case, and it did not create the same kind of rights and obligations as was being created here. In Mr Gallagher's case, the SIP was directly connected to the financial package of benefits he received as remuneration for his services as an employee, and it involved matching shares paid for entirely by his employer. There is a secondary point to watch out for as well regarding the particulars of employment, and Ponticelli should notify Mr Gallagher of the changes. So at the time of the transfer in May 2020, the identity of Mr Gallagher's employer changed, and he couldn't continue his membership of the Total Exploration Plan, but he was entitled to membership of a Ponticelli plan, which was to be of substantive equivalence, and he should have been notified of both these changes as required under Section 4 of the Employment Rights Act 1996. So what does this case mean for employers? Well, it's easy to see why employers have generally tried to keep share schemes separate from the employee's contract of employment. and scheme rules often say that they are not contractual and participation in a share scheme won't be specifically excluded from the employment contract. Employers do try to exclude a claim for damages for loss of entitlement under the scheme if the employee is dismissed, but they also try to avoid the rights of employees to participate passing to a buyer under TUPE. However, in the Mighty case I mentioned earlier, there was a profit sharing scheme, and now in this case, the EAT have found that the right to participate in the SIP was a right in connection with the transferring employee's contract. And this means that the new employer, the transferee, had to provide a substantially equivalent share incentive plan. Of course, in reality, providing this benefit may be a significant cost burden for the new employer, and there may be practical difficulties in providing a share scheme of substantial equivalence. It is especially difficult for a transferee that does not operate a similar scheme for its existing employees, or where the transferee is not a listed company or cannot offer shares at all. However, the Ponticelli case does leave open some difficult questions, including what the obligation is to establish a substantially equivalent scheme and what it means in practice. It's also not clear what happens if participation in the scheme is a discretionary benefit that could be terminated at any time. Could the transferee set up a new substantially similar scheme and then terminate that scheme, relying on that unilateral right to terminate it? Whilst there is uncertainty on some of these issues, in all cases, it's key that the transferee should assess the costs associated with implementing the transferring rights and benefits, not just those which are obviously contractual, but also those which are in connection with the employment of the transferring employees. Once a transferee fully understands the total package that the employees are on through due diligence, the exact action that transferees want to take, having considered that, will often depend on the commercial deal between the parties. Thank you for joining us for this week's TUPE Tuesday podcast, and please join us again next week for our final instalment on the changes up to EU law which may be coming next year. In the meantime, if you want to catch up on the previous TUPE Tuesday podcasts, they are available on our website, and as always, if you have any questions, please do contact one of the team. Thank you, and I hope you join us next week.
Thanks for joining Gowling WLG for this podcast. If you enjoyed this episode, be sure to check out our website at gowlingwlg.com for more useful insights and resources. And don't forget to subscribe to ensure you join us for our next episode.